Hello, everyone, and welcome to today's program, The Insurance Universe Post-Pinto v. Farmers. Our wonderful program speaker today is the Honorable Judge Puri of ADR Services. I'm Ala Policastro, Director of Education and Professional Development with BHBA, and with us today is also Katie Jones, the Marketing Production Manager at ADR, who will introduce Judge Puri. I'm going to turn it over to Katie.
Thank you so much, Ellen. Thank you to the Beverly Hills Bar Association for having us at today's presentation. I would love to introduce Judge Vedika Puri. She started law school when she was 20 and wanted nothing more than to be on her feet and in front of a jury. She worked in the trenches, first as a defense lawyer and then a plaintiff's lawyer for a total of 24 years in state and federal courts throughout California doing just that. Almost nothing was more humbling to her than presiding over a jury trial as a judge or the hush of the courtroom between when a jury panel was sworn and her opening argument for trial. Welcome to the first Indian American judge appointed in San Francisco Superior Court's bench, Judge Vedika Puri. Judge Puri has dedicated close to 35 years to litigation and dispute resolution, first as a trial lawyer, then as a respected judge, and now as a mediator. She built a distinguished career handling high-stakes civil cases, earning recognition for her expertise in insurance law, legal malpractice cases, and complex litigation. As a judge, she presided over a wide range of civil and criminal matters, managing trials, settlement conferences, and complicated law in motion with fairness and efficiency. A skilled negotiator and problem solver, she has successfully resolved hundreds of disputes by understanding the legal, financial, and human dynamics at play. Now focusing on mediation, she leverages her deep courtroom experience and evaluative approach to help parties reach clear and practical resolutions. Thanks for putting this program together, Judge Puri. I'll pull up your slide deck and let you take it away.
Thank you. Good morning, everyone. Good morning. We are here to discuss a very, very specific insurance topic. Like I like to say when I give this program, insurance nerds unite. Insurance is what makes the world go round. It's fascinating to those of us who love it. And the program I put together for you today has to do with what's been going on post-Pinto. For those of us who have been in the insurance coverage industry, I was on the defense side, like Katie said, and then on the plaintiff side, we know that the Pinto case, which I'm about to go through, was a big deal. And this entire program has to do with an insurance company's duty to settle, what it's considered to be a reasonable conduct during a settlement process for its insured, and what's not. The very interesting part about what Pinto did, it literally changed one of our jury instructions here in California, and that's a fairly rare thing. So when a case comes down and says you got to fix something in a CACI instruction, practitioners sit up, we pay attention. So what is the general rule? Just starting at our first slide here, we all know it. Any of us have been practicing in this area or even know about it. An insurance company has the duty to settle within policy limits. It's part of their implied covenant of good faith and fair dealing. And what's the point of a duty to settle within policy limits? So that the insured, hopefully, mercifully, doesn't get exposed later on to a judgment in excess of an insurance policy limit. Now, if an insurance company breaches this duty, then it could be subject to liability in tort law, bad faith. That's our general rule. We know this from the Communal case from 1958. We know this from a line of cases, not just PPG in 1999, as far as what the consequences for breaching the implied covenant of good faith and fair dealing with respect to settlements. So let's take a look at what the Pinto case actually did. Folks, what I'm going to go through with you today is the Pinto case, the two subsequent cases that have actually dealt with the same subject matter. One is called Hedayati, the other one is called Planet Bingo. All of these cases came down in 2021, all pretty close in time, which is also unusual. Insurance cases are extremely dense when it comes to the factual timeline, exactly who said what to whom, what letters went, what FedExes came in. So what you're going to see in my PowerPoint slides are detailed timelines to help us go through these cases and understand what the various courts of appeal held. What's also very interesting is Planet Bingo came right after Pinto. Hediati came after that. Both Planet Bingo and Hediati were decided by the Fourth District Court of Appeal, different divisions within months of each other. It's really interesting how these divisions work. Sometimes they have no idea what's going on, obviously, with the other division. So when we look at, let's just quickly go to slide 4. This is a quick timeline of the cases I was just referring to. So Pinto comes down in March of 2021, and that is a reversal of a jury verdict in favor of the insurer. Then we go to Planet Bingo, which reverses a summary judgment. This time, the Court of Appeal sides with the insured. Planet Bingo does not cite to Pinto, but it's talking about the same premise, the same idea about what is reasonable conduct in handling a settlement demand, post-litigation maybe, and pre anything verdict coming down. Then we go to Hediati, which you can see. So Planet Bingo was about 10 days after Pinto. Then we go to Hediati, which is that should say MSJ, my bad, reversal, again in favor of the insured. It was decided in August of 2021. Now, it does cite Pinto, does not cite Planet Bingo. I can't tell you how the COA and the mysteries of how it works, but I can tell you that obviously the law coming out of all these 3 cases is incredibly important to the insurance industry and helps guide how insureds and insurers handle settlement demands. Okay, so let's go to the very detailed, it looks dense, but I'm going to get you through it. This is the claims handling timeline in the Pinto case. So let me talk to you a little bit about this case. This is where there were 4 folks in a truck coming back from a party, Lake Havasu, Arizona. The truck goes off the road and flips. It's a terrible, terrible accident where Pinto, the named plaintiff, is actually rendered a paraplegic. There are other folks in this truck. You're going to see these names come up. They're Orcutt. These are the last names, Martin and Williams. I believe it was Miss Martin. She suffered brain damage. I mean, this was a bad, bad accident. The question becomes who was driving. There's actually some dispute the whole way through as to who the driver was. So the truck is insured by Farmers. So in April 9th of 2013, claim gets tendered to Farmers. Farmers is the insurance company for the truck and driver. It's a $50K policy with $100K limits. We go to, now the claim has begun. We have adjusters getting involved, Farmers on top of it. Adjuster number 1 calls to find out information about the other passengers, Orcutt, Martin, Williams, who else is involved, trying to gather information as is normal with claims handling. Adjuster number 2 gets involved by the end of April, and it's that adjuster that interviews Miss Orcutt and interviews Miss Martin. Again, obviously, gathering information. This is what insurance company is supposed to do. 2 months later, we see in the file, we're now at the end of this left-hand column, where Mr. Pinto's attorney sends a demand letter to Farmers. Now, there's an interesting, it says mail to Oklahoma there. Let me just explain what happened here. Even though the adjuster for Farmers gave Mr. Pinto's attorney her fax number, Mr. Pinto's attorney decided to mail the letter to a claims handling center in Oklahoma. So there's going to be a little bit of a delay, obviously. We don't know why that happened, but it's the way it went down. Now, the demand itself expired by its terms in 15 days. It said, listen, we are demanding policy limits. We require declarations from your insured, Martin. Didn't really reference Orcutt. But we want declarations that they weren't in the course and scope, obviously, to negate that there were other policies out there. and get back to us. So let's go to the next column up here where it says, no, I'm sorry, same slide, Katie, my bad. July 5th, up there, Farmers receives the demand and assumes it's on behalf of Martin and Orcutt. Orcutt would have been a permissive driver. There was a dispute. Who drove? Martin, Orcutt, we don't know. Farmers again, July 6th, does the right thing, forwards the demand to its insureds. We can't quite find Orcutt, so Farmers hires a PI. Again, now we're in mid-July, July 11th. Time is ticking. We're on a 15-day clock. What happens? Farmers calls plaintiff's counsel and says, can we get an extension? We're working on this. No response. So Farmers continues to operate under the 15-day deadline. And that should say under the July 13th box right there, the PI, not the plaintiff, the PI locates Orcutt. In a call, Orcutt confirms, I'm not acting in the course and scope of any employment. I don't have any of their insurance, but Orcutt never signs the declaration sent to her to that effect. Not much Farmers can do about that. They've done the best they can. We come to July 15th. Farmers Counsel is within the deadline time. They send a letter to plaintiff's counsel, tendering limits, asking certain questions. I believe they got a deck from Martin, but of course they couldn't get one from Orcutt. But they give up the information that they have and they tender the limits. They think, done. Before we get to the next slide, let me tell you what happens 2 days later. The attorney for Mr. Pinto rejects the check that he actually asked for in the beginning. On July 17th, saying that Farmers had failed to, quote, unconditionally accept the generous offer to settle this case, close quote. The lawyer for Pinto rejects the $50K check. And in doing so, in his letter, the lawyer says, quote, my client, with his astronomical medical bills and devastating injuries, would be a fool to accept Farmers' $50,000 without knowing the exhaustive policy limits or course and scope status of Miss Orcutt. We're going to file suit. Okay, those are the key facts you need to know. We can go to the next page now, Katie. Next slide. Let's talk a little bit about the procedural history. What happens is Pinto then sues Orcutt and Martin. They settle. Pinto receives an assignment to pursue Farmers. A key part of the settlement, that the settlement would be treated as the equivalent of it was 9.93, about a $10 million judgment. So that's the underlying case. If you look at point number 1 there on the left part of the slide, after Pinto obtained a judgment against the owner of the car or the drivers far in excess of the policy limits, the Orcutt and Martin then assigned their claims to Farmers, against Farmers to Pinto, and then the bad faith case ensues. So during the bad faith trial, extensive evidence was presented by both sides concerning everything we just talked about. The reasonableness of the insurer's conduct in adjusting the claim and in failing to accept the offer. That's the premise of the bad faith case. There was a special verdict form that the jury used in this case, but it didn't ask anything about the reasonableness of the insurer's conduct. So specifically, it asked the jury to make these 3 findings. Here is, the next slide is the actual verdict form that was used in this case. It said, number 1, did Pinto make a reasonable settlement demand? Yes. Number 2, did Farmers fail to accept a reasonable settlement demand for an amount that was within policy limits? Next slide, that answered yes. And the next slide shows number 3, was there a monetary judgment greater than the policy limits? That was it. Those were the 3 questions. Now, if you could just go back to slide 7 for me for a moment. Folks, what's missing from question number 2? The Court of Appeal said the key fact that's missing from question number 2 is unreasonableness. Did Farmers unreasonably fail to accept a settlement? How can you have bad faith liability without unreasonable conduct? That's the premise of bad faith law. So, key holdings from Pinto, going to slide 9, in evaluating this particular verdict form are here. Number 1, simply failing to settle does not meet the standard for bad faith. A facially reasonable settlement demand might go unaccepted due to no fault of the insurer. For example, if some emergency prevents transmission of the insurer's acceptance. The court has never held the failure to accept a reasonable settlement is per se unreasonable. Although CACI 2334 describes 3 elements necessary for bad faith liability, it lacks a crucial element: bad faith. To be liable for bad faith, an insurer must not only cause the insured's damages, it must act or fail to act without proper cause. For example, by placing its interests above those of the insured. So here, the special verdict form we just saw specifically tracked the CACI. Probably the judge, probably the lawyers, not farmers' lawyers, thought that they were covered. We're using the CACI form. That's got to be protected on appeal. How could we go wrong with a verdict form that tracks the CACI? Well, not so. Going to the next slide, the Court of Appeal here in Pinto said, based on what we see, quote, no evidence suggested farmers' conduct caused the settlement to fail. Farmers attempted to accept Pinto's settlement offer, timely tendered both the policy limits and Martin's declaration. Settlement failed only because Pinto rejected the tender on the ground that it failed to include Orcutt's declaration. But no evidence established, and the jury did not find, that farmers should have done more to obtain that declaration. On the contrary, the jury expressly found that farmers used reasonable efforts to obtain Orcutt's cooperation, and her lack of cooperation prejudiced the insurer. Farmers therefore did all it could to achieve a settlement. Based on that, we look at the next slide. This is the CACI 2334 pre-Pinto, tracking that verdict form. You've got your basic 1, 2, 3. You brought a lawsuit for a claim that was covered. Number 2, failed to accept a reasonable settlement demand. Number 3, there was a judgment greater than the policy limits. Post-Pinto, this CACI was amended. Now we have an amended 2334 on slide 12. And look how much more detailed we get. Just going to slide 12 there real quick. Thank you. So post-Pinto, we get detailed and we break up the information. Number 1, there was a insurance policy. Number 2, there was a claim. Number 3, claimant made a reasonable demand to settle for an amount within policy limits. Number 4, failure to accept this demand. But most important, here's the rub that was not in the original CACI. Number 5, that the insurance company's failure to accept the settlement demand was a result of unreasonable conduct. And 6, that a judgment was entered for a sum greater than the policy limits. Again, 7, all these 5, 6, and 7 are the keys, that the failure to accept the settlement demand was a substantial factor in causing harm. So this CACI ties together everything the court was talking about in Pinto to make sure that if a jury is going to find bad faith liability, it has to be premised in unreasonable conduct. And according to the Court of Appeal, farmers did not engage in unreasonable conduct. If anything, they did the best they could to comply with a short timeline and then tendered their policy limits. What more could they have done? So that is the background against which we will now consider the next few cases. So we turn next to the Hediotti case. Let me talk to you about the facts in Hediotti. Miss Hediotti herself was a 43-year-old medical school grad. She was studying for her board exams, folks. She's walking across the street in October of 2012, and she gets hit by a car. Her injuries were extraordinarily severe. This is a catastrophic injury case if there ever was one. One of her legs was severed. The other leg was shattered. She was in a coma for several weeks with broken bones throughout her body. I mean, it was not looking good at all for Miss Hediotti, who was innocently just walking one day when she was crippled for life. So a claim is tendered to Auto Club. That's the carrier for the driver. It's a $25K policy. So we're going to dive in just like we did for Pinto. I'm going to go through the facts with you because, again, this is extraordinarily factually driven assessment when we're trying to figure out whether a proper demand for policy limits has been made, whether there's exposure to the insurer above those limits because of its conduct. Everything will turn on getting your chronology of facts straight. So let's go through it. Let's look at the claims handling timeline. So this next slide, this comes purely from the Auto Club's internal file, and you'll be able to tell why in a second. So October 2012, the accident has just happened, I believe, the day before. The adjuster reports internally after the first interview with the driver that the driver, quote, makes a very poor witness for himself. Now we go on to the rest of the investigation that the insurer is conducting. And here are the internal notes that the insurer is making almost right away. So first, during that initial interview, the insured gave his signed permission to release policy limits so that Auto Club could move quickly to settle any potential claims if they exceeded his policy limits. This is a quote from the actual case explaining what they saw in the claim file. Now, this is important because, as we know, there's a general rule. Insurance companies have to disclose policy limits, the policy, but in this case, for some reason, Auto Club was not providing this basic information. So the Court of Appeal is looking really hard at what did the Auto Club know real time and what was it doing in response to the claim. So here, even though they received permission from its insured to release the policy limits, they didn't. Next point, bullet point there, driver admitted at the time that eyewitnesses told him he ran the red light. In other words, his culpability is not looking good, and the insurance company knows it. Next bullet point, the adjuster immediately recognized, this is again according to the Court of Appeal, and explained to driver that liability in excess of his policy limits was likely due to his speeding and hitting a pedestrian, even if we accepted only a percentage of responsibility. So here we have the insurance company acknowledging that they're going to have to take the hit for this one, that the driver is likely going to be found liable. And the final bullet point there on the left-hand side, the adjuster's interview notes reflected that driver disclosed he had, quote, no other insurance, no homeowners or PUP umbrella policy. He does not own anything, no real property. He is currently unemployed and living with his parents. Okay, this is almost a nightmare situation for an insurer when trying to evaluate liability, apportionment, assessing what's going to happen next. This becomes an important point because for whatever reason, Auto Club is also remiss and they don't disclose to Hediati the scope of the insured's financial status, whether he has other insurance. Auto Club was just not relaying information that they should have been. Bottom line is what the COA is looking at here. Okay, going over to this column on the right-hand side. An internal note, which is quoted by the COA in their decision, immediately upon reviewing the adjuster's report, which included a newspaper account of the accident and description of Hediati's injuries, an Auto Club manager recorded on the company's notes, quote, would appear that our 25K limit is gone. So folks, all along, right away, Auto Club realizes their insured's exposure and frankly, their own exposure. 10/30/2012, so we're at the end of the month. It's been a month since the claim was filed. The adjuster drafted a letter to Hediati's counsel that attached a copy of the insured's declaration that he didn't have any other insurance, but for whatever reasons, this letter doesn't get sent. It just lives as a draft in the file. What does get sent a day later is a different letter that says we're going to tender our policy limits, but doesn't give any of the details that Hediati sought. Other insurance, course and scope, things like that. So now we're going to go to the actual settlement demand timeline, because this becomes very important to the Court of Appeal too. So what happens the week of Thanksgiving, of course, November 20th, 2012. It's a Tuesday. I looked it up. Hediati's attorney sent a settlement demand for the 25K conditioned on receiving a course and scope declaration and that no other insurance applied. There were some other terms and it was conditioned. It was a 1-week settlement turnaround. So that would take us to the Tuesday after Thanksgiving week. So, of course, the next day, this is sent by FedEx overnight. The insurance company receives the demand. But now we have Thanksgiving, Thursday. And guys, what usually happens on the Friday after Thanksgiving? Typically, most offices are closed. It's considered a holiday as well. So we lose that Thursday, that Friday, that weekend. The first time the insurance company kind of sees and pays attention to this 1 week demand is on the following Tuesday, November 27th. The demand has now expired that Tuesday. There was a request for extension that day, but the answer was no. Later on in deposition, the claims manager offered no explanation for why no one at Auto Club responsible for the driver, Van Wyck is the driver's name, appeared to have seen or acted on Hediati's offer for more than a week after it arrived. So what we're seeing are these very short fuse settlement demands, and the COA is trying to go through it and figure out, well, should the insurance company have been responding quickly? Should the insured have given more time? Who was acting reasonably? Who was doing what when? So what happened in the bad faith case? There was a settlement of the underlying case for a very large settlement. There was an assignment of rights. It was over 26 million, I want to say. Assignment of rights by Hediati to go after the insurance company, go after Auto Club. So what happened at trial court level? The insurance company wins summary judgment on the bad faith issue. The Court of Appeal on the next slide gives us kind of the key quotes from the trial court ruling. So these are quotes from the Court of Appeal, but talking about the trial court ruling. The trial court granted MSJ reasoning that the Auto Club never refused any of plaintiff's policy limit settlement demands. All that plaintiff has shown is that defendant failed to respond to plaintiff's self-imposed arbitrary deadline to a demand defendant received the day before Thanksgiving for not just $25K, but also for a signed deck from the insured attesting to certain facts. And this is again from the trial court ruling. Although plaintiff's deadline to accept the policy limit settlement offer was the following Tuesday after Thanksgiving, plaintiff inexplicably required the response to be sent by UPS or FedEx overnight delivery, not by fax or courier, meaning that it had to be sent the Monday after Thanksgiving. So the trial court therefore said there was no real reason for the mega short deadline, and therefore Auto Club's response or lack thereof was immaterial. So the trial court said the insured's counsel and the way that they set this up was not reasonable, frankly, that it was too quick of a deadline, it was over a holiday, and how can you possibly find Auto Club to be in bad faith on these facts? So that's why the insurance company won summary judgment. Lower court. Well, the Court of Appeal did something different. Going to our next slide. The Court of Appeal says, in essence, the trial court found no reasonable trier of fact could conclude Auto Club's conduct in failing to meet the clear terms of Hediati's settlement offer and secure a release constituted a breach of duties to the driver, Van Wyck, under his liability policy. In other words, as a matter of law, the trial court found Auto Club did not violate its implied promise to Van Wyck to handle policy claims with good faith and fair dealing regarding his interests. We disagree with this analysis. So let me explain to you. There were 3 reasons why the Court of Appeal disagreed based on my reading. So if we look at slide 18, the first couple bullet points there is the court explaining the basic law regarding duty to communicate. But reason number 1, the Court of Appeal found that Auto Club had failed to convey Hediati's offer to Van Wyck, to the driver, and that the breach of the duty to communicate alone, so looking at the bottom 2 bullets there, here it is undisputed that Auto Club failed to convey Hediati's November 20th settlement offer to Van Wyck. Auto Club nonetheless sought to support its summary judgment motion by characterizing this failure as reasonable under the circumstances. Such an approach will almost inevitably raise contested issues of fact, as it did here. Number 2 reason that the Court of Appeal reversed the trial court ruling was because it decided, it said, wait a minute, we're focusing on the insured's lawyer's conduct. We should really be focusing on what Auto Club was doing. And Auto Club's, one of their claims manager, when they were deposed, This was the quote I showed you before, where they offered no explanation for, quote, why no one at Auto Club responsible for Van Wyck's policy appeared to have seen or acted on Hediadi's offer for more than a week after it arrived, close quote. So regardless of the Thanksgiving weekend, regardless of it being a short fuse, the Court of Appeal said if we had some explanation, if someone had said it was Thanksgiving, we just didn't pay, we weren't looking, we don't look at our mail on those days, on national holidays. But that's not what the evidence was. And so the Court of Appeal said, well, then the onus is on Auto Club to have figured that out and explained why they didn't move on the offer. Finally, the third reason why the Court of Appeal reversed the trial court, which is also quite interesting, is according to the trial court, there was a submission under seal of Auto Club's claim file, claims handling policies. And in those claims handling policies, although they can't be quoted because they were under seal, they specifically addressed how to comply with excess policy limits demands and handling standards for those. The guidelines stated that they were intended to address the most frequent and highest exposure situations. And the standards included specific procedures for handling time-limited settlement offers. And although that these are under seal, the Court of Appeal said, quote, after reviewing the documents ourselves pursuant to our de novo review, we agree with Hediadi's contention that the Auto Club failed here to follow its own guidelines. So those are the three reasons the Court of Appeal overturned the trial court. And this was a August 11th, 2021 decision, which is, again, just a few months after Planet Bingo. When you look a little bit deeper into Hediadi, there's some very interesting passages. It's a very dense opinion, but evidence of what the Auto Club did not do are kind of the key parts of this opinion. Those are pages 849 and 850. And that's what the Hediadi decision did. And I went a little bit out of order here. We're going to go back now to the Planet Bingo decision. And then I'm going to focus on, after we talk about Planet Bingo and similarly the facts and how the court held, there is the relatively new, enacted last year, CCP section 999. I know that's a weird number, right? We're all used to saying 998. 998. Judge, you're making up 999. No, I'm not. It's a new statute that was enacted, and it looks to me to be directly addressing some of these issues that we've been talking about, the short fuse settlement demands. What will and will not be considered a reasonable settlement offer under this statute. It's trying to clean up some of these factual scenarios that can lead to years of litigation. But I'll talk about that in a minute. All right, going to Planet Bingo. This also, as far as I'm concerned, these are all fascinating cases. Planet Bingo is a company that actually designed and supplied gaming devices in the UK. One of its customers, Leisure Electronics, which was insured by AIG, distributed and leased these devices. That's the distributor. And then a customer, Beacon Bingo, leased Planet Bingo's devices from Leisure and opened a bingo hall in London. Okay, so where's the issue? What led to the insurance claim here? In 2008, I know this is a very long, tortured procedural history in this case. If you want to reach out to me separately, I'm happy to share my notes on it because I literally made pages and pages of notes to try to understand the long history here. But in 2008, there's a fire at the Beacon Bingo's building, not to be confused with Planet Bingo. And claims were made both to Leisure's insurance company, AIG, as well as to Planet Bingo's insurance company, Burlington. Lots of things happen during this claim that are not relevant for our purposes, multiple lawsuits and appeals. Finally, Planet Bingo goes out of business. In 2014, AIG pays a claim by its own insured, Leisure. It pays $1.6 million, 1.6 million pounds, I believe, to settle with Beacon Bingo, and then goes after Planet Bingo and says, you owe us this money, Planet Bingo. This was your design gaming device that was a problem. So there's a lawsuit for recovery. Burlington, Planet Bingo's insurance company, accepts the defense. Most of the case is resolved, but as part of the bad faith suit, again, talking about demands, what that means in this post-Pinto universe, Burlington files an MSJ saying we had no pre-litigation duty, because this was in pre-litigation for years and years and years, to settle. We never received an offer to settle within policy limits. How could we be charged with doing something in bad faith then? Well, the trial court granted summary judgment on this specific ground. It said, yeah, there was no offer to settle, and that's pretty much has to be some kind of prerequisite before you're going to charge an insurance company with bad faith for failing to respond to a settlement demand. Well, in this decision, this was the case that was 10 days after Pinto. It doesn't cite to Pinto, but again, it's in the same idea and rubric of reasonableness of settlement demands. How do we handle them? This case goes so far as to reverse the summary judgment. This time now it's in favor of the insured. And we're going to skip here to slide 22. Oh, okay, it goes to 21. Thank you. Here was the holding by the Court of Appeal that, quote, the existence of an opportunity to settle within the policy limits can be shown by evidence other than a formal settlement offer. And that one subrogee sent a subrogation demand letter, which at least plausibly represented an opportunity to settle within policy limits. That opportunity, the court concluded, this is my note, was enough to defeat summary judgment and justify reversal. So that's taking it to another level. The Court of Appeal said we're not going to be held up by the formality of a specific letter addressed to a specific insurance company saying this has to be a settlement demand within policy limits. We're going to say there was an opportunity to settle within policy limits, and therefore at least there's a tribal issue of fact as to whether or not the carrier acted in bad faith. That takes it pretty far. And that's a pretty important ruling for everyone to be aware of, because there could be a lot of opportunities to settle. And what does that mean? I think there could be quite a bit of litigation from that. Okay, so let's go exactly. What does that mean? I think legislature tried to help out. And in January 1st, 2025, this new law, this new CCP section took effect. It's retroactive to any demands after January 1, 2023. What does this entire section do and say? I will tell you, my research shows that we don't have any cases that are interpreting this section yet. It's still new. It's still only about a year and 4 months out from this. I absolutely anticipate there will be litigation because of the different words used, and in the insurance coverage universe, that's how it goes. We need cases to help us define what factual scenarios will lead to liability or not. We just do. That's the way insurance coverage works. So this section specifically starts by saying it is declared to be the public policy of the state of California that prompt settlements of civil actions and claims are encouraged as beneficial to claimants, policyholders, and insurers. And what this section goes on to do, I've just got the little breakout here. By the way, there's going to be some handouts that I think are either coming or you can probably already download on the Google Drive. I've put the entire statute into those handouts so that you have it handy. Do take the time to read the statutes. I say that not only because of the great prevalence of AI these days, but because I went and looked at the Rudder Group explanation for CCP section 999 just to see if they had something interesting or if there's new cases about it. And if you can believe it, one of the sections talks about section 999.5, which you see here on the right-hand side of your slide. This new statute only applies to certain kinds of coverages. One is bodily injury / personal injury, auto, homeowner, commercial premises liability, and wrongful death. When I read the Rudder Group section, they had left off the wrongful death piece of it. And I can give you the exact section that doesn't have it. that's a problem. Wrongful death claims are extremely serious. Obviously, they're very high exposure. They're extremely emotional, distressing to the victims' families. They are big ticket number and items. I hate to say it like that, but for insurance companies, there could be possibly explosive claims. So take your time to read the actual statutes and see how they apply. They're not long. And let me take you through them quickly. So what CCP section 999.1 does, it specifically, we're trying to define, legislators trying to tell us what a pre-litigation demand, a settlement demand should look like. And if it doesn't look like it, it may not be considered a reasonable demand for settlement that would trigger insurer liability. So 999.1 talks about the form of the time limit demand and its requirements. It talks about the fact that it cannot be less than 30 days, that the time limit put in there cannot be less than 30 days. Now, I think that directly addresses some of these short fuse situations that we've seen. It will also eliminate the issue of, well, was it a holiday? Was it a weekend? Why weren't the insurance folks looking at this? It gives you a bright line number of days that will be considered time period within which the demand must be accepted shall be not fewer than 30 days from the date of transmission if the transmission is by email, facsimile, or certified mail, or not fewer than 33 days if the transmission is by mail. So it puts a clock on sending it and responding to it. This is the time frame that everyone has so that there's no confusion. And it also talks about, what do you have to put in the time limit demand? The date and location of the loss, claim number if known, a description of all known injuries, and reasonable proof. Okay, guys, now that's going to be the subject of litigation. What's going to be reasonable proof? But it specifically says, which may include medical records or bills sufficient to support the claim. The demand also must be a clear and unequivocal offer to settle all claims within policy limits, including the satisfaction of all liens. So that all these things we saw back and forth, particularly in the Pinto case, requesting, course and scope. One of the requests in one of these cases had to do with liens. Legislatures trying to go ahead and get ahead of these issues. Let's get all this done in the demand so that there's no confusion for the insurer who's trying to respond within a 30-day time limit. So no more 7-day, 15 days. And again, this statute only applies to certain kinds of policies, and it only applies to pre-litigation demands January 1, 2023 forward. They did make it retroactive, which is kind of interesting. Okay, section 999.2, where the insured needs to send the demand letter. Also eliminating what we saw in these cases that I've been talking about today, which is the claimant shall send their time limit demand to either of the following: the email address or physical address designated by the liability insurer for receipt of time limit demands for purposes of this chapter, if an address has been provided by the liability insurer to the Department of Insurance and they've made it available. And then, so that's the one that the insured has to use. And then A2 under this section specifically says the insurance representative assigned to handle the claim if known. Now, maybe the insurance company doesn't have that information available. So section B of 999.2 says to implement this section, the Department of Insurance shall post the email address or physical address designated by the liability insurer for receipt of time limit demands for the purposes of this chapter. So we're trying to tie it all up. There's got to be somewhere clear for the insured to send the information and for the insurer to accept it. That's 999.2. Going to 999.3. This is titled Acceptance of Demand, Clarification, Additional Information. So this governs what the insurance company needs to do in response to a time limit demand. Once the clock is ticking, of course, an insurance company has the standard options: accept partially, accept in full, deny. We know that part of it. But here, what legislature does with this section is, upon receipt of a time limit demand, an attempt to seek clarification or additional information or a request for extension made within the made within the time limit demand shall not, in and of itself, be deemed a counteroffer or rejection of the demand. So we're trying to eliminate a little bit of the gamesmanship. When a plaintiff's lawyer responds to a carrier and says, we construe your answer, even if has a check with it, to be a counteroffer, this section takes out that option for a plaintiff's counsel, again, with respect to certain policies. I feel like this is all very much directly in response to what the courts have been saying in Pinto and Hediati in all the 2021 decisions that we've gone through. I think legislature is trying its best to head off some of the gamesmanship on both sides, where an insurance company can say, well, we didn't see stuff, it was a holiday, and an insured says, well, 7 days is reasonable. They're trying to cut through it. Hopefully that'll be the case, but I do see this headed to some more litigation to figure out what some of these terms in the statute themselves mean. So sticking with 999.3 for a moment, the insurer response. Section C specifically says, if for any reason an insurer does not accept a time-limited demand, the insurer shall notify the claimant in writing of its decision and the basis for its decision. This notification shall be sent prior to the expiration of the time-limited demand, including any extension agreed to by the parties. And, quote, shall be relevant in any lawsuit alleging extra-contractual damages against the tortfeasor's liability insurer, close quote. So we're directly addressing the issue of bad faith claims arising out of settlement demand conduct and trying to ensure that whatever the flow was between the carrier and the insured comes into evidence, is evaluated as part of a bad faith claim, and that there's not an automatic trigger here where an insurance company is gonna be on the hook because it took too long to respond. You've got these different excuses that come along. I think legislature worked as hard as it could to try to eliminate the gamesmanship from both sides on this issue. Okay, so now we go over to obviously these are all read together. 999.4. This, in summary, is what will and will not be considered to be a reasonable demand. So this is incredibly important. Again, I urge you to read the actual text. It is in the handouts. That's what I'm looking at right now. I thought all of our eyes would completely glaze over if I put this into the PowerPoint slides itself. So I'm just giving you the headlines of what these statutes, as far as I'm reading them, what I think they mean. Again, we don't have cases interpreting them just yet, but they're coming. So point 4 talks about what a non-compliant time limit demand is and how it dovetails with discovery. So section A, in any lawsuit filed by a claimant or by a claimant as an assignee of a tortfeasor, I'm not skipping parts of this to paraphrase, a time-limited demand that does not substantially comply with the terms of this chapter shall not be considered a reasonable offer to settle the claim. In other words, you got to do the basics. Otherwise, you're going to be out from a bad faith claim at the get-go. And it specifically says for the purposes of a lawsuit alleging extra contractual damages against the tortfeasor's liability insurer. This section does not apply to pro pers. And if there's any issue with discovery, the Discovery Act is going to prevail. So what's the point of this is comply with the basics of the statute if you're sending a time limit demand. Otherwise, it's going to be peace out to begin with. Do the basics. Then we go to the final section, which talks about the scope of this, 999.5, which talks about the exact kinds of coverages in play, which are this section applies to automobile policies, homeowner policies, premise liability policies, bodily injury, personal injury claims, and wrongful death claims. So that's pretty broad scope. There is also obviously a large segment that's left untouched by this, but by and large, these are probably where we're seeing the settlement demands come in, and we're seeing a lot of litigation over reasonableness or unreasonableness of the insurance company's conduct. And this section 0.5 is also where it is made retroactive. This chapter shall apply to time limit demands transmitted on or after January 1, 2023. So that is your new section 999. Read it and know that it applies, and make sure your folks, whether you're an attorney for the insurance company or insureds, this is incredibly important information to know and file away and let your colleagues know about, so that you have easy reference to what is supposed to be done with a time limit demand and how to handle it, at least at the basic level. When we're going to get rid of these kind of it's over a holiday, we don't know what's happening, and you got to get back to us in 7 days, otherwise you're done. We're cutting through that now. So these are the big things that have happened in the settlement demand universe since 2021.
Thank you, Judge Peary. I do want to share that Judge Peary has also included her direct contact information in the slides if you have any follow-up questions for her. With our remaining time, we do have a few questions from the audience that I would love to pitch to you, Judge. Our first question is, are there any specific changes in the law with regards to insurers' obligations to third parties under CCP 998 offers, not the 999, when liability is clear and the insurer continues to draw out the case or ignore the 998 offer?
Say that last part, or ignore the 998 offer?
When liability is clear and the insurer continues to draw out the case or ignore the 998 offer.
So my understanding is there is not like what I've been talking about, like the sea change that we've seen from Pinto. Certainly you have your remedy if an insurance company is ignoring your 998, and the liability, you've sent over the information, the liability is clear as day. But no, I don't know of any major sea change in the law that affects the current status of how you would pursue an insurance company that's not behaving the way it should, particularly in a clear liability case.
Mm-hmm. And another 999 question. Can you clarify if, how, and when 999 applies after a case has been filed and a trial date set? Or is it purely in pre-litigation situations?
So the first section, that's 0.1, answers this question this way, and it's pretty specific. B2 says time limit demand means an offer prior to the filing of the complaint or demand for arbitration to settle blank, 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 blank. So to me, we're out of as soon as the case is filed, you're in a different realm. I would say 999 would not apply. This is meant to be the true pre-filing statute.
Mm-hmm. And you also mentioned that it does not apply to pro pers. So does that mean that pro pers are excluded from limitations, formalities, and requirements of the time limit demands under 999?
That is my interpretation of why they're letting go pro pers, because a pro per would not be as sophisticated as counsel in being able to understand, frankly, the statute and the way it works, or these cases that we've been talking about and the very, very detailed, complex timelines. So yes, that is my interpretation of what that special exemption means.
Mm-hmm. And another kind of application question, is there a consensus on whether 999 offers apply to UIM or UM or first party claims?
I would say there's no consensus because we haven't had any cases yet. I honestly don't know the answer to that, but I think that personal injury / bodily injury is pretty darn broad. I think legislatures trying to address a large swath of cases, trying to help, again, both sides, the victims in those terrible accidents and tragedies, as well as detail what an insurance company's responsibilities are. So I would say that they were covered, but that's just me.
Mm-hmm. And, looking at your mediation experience, Judge Peary, it seems that these strict timelines and kind of ambiguities may open up opportunities for gamesmanship in resolving these disputes. Have you seen that happening, or how do you recommend folks, deal with
Yeah.
gamesmanship on the part of the insurance providers? What do you think?
It happens all the time. It happens all the time. And I don't know that it's born from game playing. I think that you have folks, plaintiffs who are gravely injured and trying to get recovery. They're trying to find a way and a path, a legitimate path to be compensated for that injury. So part of that is what drives these shortened timelines. There is frustration that builds up. Why haven't we gotten basic information from the insurance company? And then on the insurer side of it, they could be hustling. Like you saw in the Pinto case, the farmers folks, they were hustling. They were operating under a 15-day deadline. They were not just sitting around. And they tendered their limits within those 15 days. So when I see it in mediation, I call it like I see it. I'll tell plaintiff's counsel, listen, I think your timeline is a bit tight here given ABCD. Let's work through this a little bit more. Or vice versa. On the insurance company side, I'll be like, what have you guys been doing for 3 months? And if they can show me their claim and say, listen, we did ABCD, I'll be like, okay, got it. You're on it. You're on top of it. Great. There's a way forward here. So I really do see both sides of it, and I will try to diffuse any of the frustration and move us forward to a resolution. The insurance companies don't want a bunch of claims hanging out, particularly high exposure ones. And certainly the plaintiffs have a lot of caseload and they're trying to get resolution for their individual clients. So there is typically a path forward.
Excellent. Well, that covers most of our questions from the audience.
Okay.
If anybody else has any last minute ones to throw into the Q&A, please feel free to do so. But we are just about at the end of our time for this morning's presentation. Again, Judge Puri has put her direct contact information into the slides, but the other handout materials should also be included on the Google Drive that consists of those additional code sections that she mentioned during the presentation. And if you have any questions at all for her, feel free to reach out. I can attest that she's very responsive.
And I'll just say a final note, one of the reasons that I deconstructed the timelines and put them in there is, particularly when I took the bench, I really appreciated a fact-driven brief or motion. So if you guys happen to be briefing these, use my handy-dandy timelines and put in the facts and compare them to your case, because that's what'll make a difference to a judge.
Perfect. Everybody loves a cheat sheet. All right. Thanks so much, Judge Puri. Thanks to the Beverly Hills Bar for hosting us and for all of you for being here this morning.
Take care. Bye.